So welcome everyone to the first Desautels Speaker Series event. It's an event that spans throughout the session, right? So this is the first Speaker Series event, and then we have our guest speaker, who I will introduce shortly. But a couple of housekeeping exercises. One is this event is divided into 3 sessions. The first session, Professor Seck would present a research for 30 minutes, and then I would ask a couple of questions in a fireside chat interview, just for students to learn about their career and, of course, think about business and human rights in Canada. And then the last session, I throw it out to students to ask questions to the audience, rather, to ask questions from our presentation or even the career talk. Now, let me formally introduce Professor Seck. Professor Sara Seck is the Judges and Kennedy Chair in Human Rights Law and the Director of the Marine and Environmental Law Institute at the Schulich School of Law, Dalhousie University in Canada. Her research and teaching interests are situated at the intersection of international environmental and human rights law, with attention to business responsibilities, climate justice, and most recently, the protection of the marine environment. Our work is informed and inspired by feminist, relational, and intersectional approaches to legal analysis, including TWIL, that's third world approach to international law. Co-edited books include the 2021 Cambridge Handbook on Environmental Justice and Sustainable Development and the 2021 Research Handbook on Climate Change Law and Loss and Damage, as well as volume 36 to 38 of the Ocean Yearbook. In recent years, she has led research for the UN Environment Programme, UNEP, on topics relating to business, human rights, and the environment, including a project designed to clarify human rights-informed responsible business climate action, and a project to develop training materials and a human rights-based approach to the plastic value chain. She's an active member of the Global Network on Human Rights and the Environment and the International Law Association. But beyond the formal introduction, Professor Seck is my PhD supervisor. And I used to share a joke that whatever wrong I have done or whatever wrong I will do, blame her. So please join me in welcoming Professor Seck.
Thank you very much, Akin, or should I say Dr. Ogunranti, Professor Ogunranti. It's a real pleasure to be here today with you in Winnipeg, Manitoba, on what I understand are the lands of the Red River Métis and other Indigenous communities on which the University of Manitoba is situated. And it's a real pleasure to have the opportunity to give this first lecture in what I understand is going to be a series on business and human rights. The picture that I have here in the background is one I took on one of my favorite hiking areas in Nova Scotia, which is the Pennant Point Trail, and Nova Scotia and Dalhousie University, of course, are located on the ancestral and unceded territory of the Mi'kmaq people. And at Dal, we say, as part of our land acknowledgement, that we are all treaty people, which has taken me a long time to really absorb and understand. But it does mean that responsibilities towards Indigenous peoples in the Canadian context are everyone's responsibilities, and that should inform how we think about the research and the teaching that we do. And so that theme, I think, is going to be part of what I'm going to reflect on as I reflect on my own journey in the business, human rights, and environment world. First, though, I wanted to share 2 slides that situate also the work that I do right now, which is in an environmental context. So I have, as Akin noted, done some work for the United Nations Environment Program on business and human rights and environment. And I think it's important to acknowledge despite the distress that might come with that acknowledgement that the world is currently in what the UN Environment Program calls a triple planetary crisis of climate change, biodiversity or nature loss, and pollution and waste. And I've got a little image in relation to the plastics pollution crisis, about which we don't yet know full scientific certainty or information on, I guess, the human impacts of this, and that is also part of the challenge of addressing environmental issues through a human rights lens when science has not been done or is uncertain or is evolving. But the general point is that we need to understand that there's an interrelationship between the climate crisis, the nature loss crisis, and the pollution and waste crisis, and we need to address all three at the same time. And so if we're linking this to business, we can say fairly clearly that one of, or perhaps the key problem that needs to be addressed is the problem of unsustainable production and consumption patterns. And I note this is in particular of the affluent, right? And so one can have a big conversation about what does that mean, but there is a lot of affluent overconsumption and overproduction to feed affluent overconsumption. And that, I think, is really fundamental to the biodiversity, climate, pollution, and waste crisis. And all of that has grave impacts on the human rights of those who are often least responsible and least involved in the overconsumption problem. So we need to figure out how to solve this crisis. We need to do it without picking on sort of one versus the other problem. We need to think about them interdependently, and we need to think about the human piece as an interdependent part of that. And so where I'm going to get to is what I'm hoping we're going to see in the future is really taking seriously this idea of business responsibilities for human rights to include responsibilities to conduct human rights due diligence throughout value chains in ways that integrates the newly recognized right to a clean, healthy, and sustainable environment. So why do I think this might actually be a place we might get to? So I like owls, so I thought this was just a cute little image. This slide is going to come up a few times as I work my way through my talk. I've divided my reflections into 4 or 5 periods based on my own education, but also on sort of moments where international instruments have been endorsed and what this might mean for how we think about and how we might get to the point where the right to a clean, healthy, and sustainable environment is part of human rights due diligence and part of tackling the problems that we face. Underneath each of the sort of headings, I have in small print some little text. This is designed to reflect on initiatives that the Government of Canada has launched at different stages to address what has been framed as a problem of corporate social responsibility for Canadian-based companies operating abroad. And a theme that I'm going to keep coming to is we need to stop thinking about outside and inside as being different. We need to integrate the human rights-based approach within Canada just as much as outside and align these initiatives. What's also happened at these different stages, and I note that I've written a lot about each of the early stages in particular, so I'm not going to share all of the things that I've written and other people have written and the critiques and the engagements, but just to note that I started law school in 1997. At that time, there was very little teaching about the rights of Indigenous peoples at the law school that I went to, which was the University of Toronto. It was really not part of our education in 97. By 2007, the UN Declaration on the Rights of Indigenous People had been endorsed at the UN General Assembly, although we'll get to the Canada reflection in a moment. In those years, towards the end, the Government of Canada came out with a standing committee report which pointed to the problem of Canadian mining companies operating internationally, impacts on environment and human rights, and a sense that Canada should do something. The government response was, we'd like to, but we can't because that would be extraterritorial, but we'll set up some roundtables to discuss this problem. That led in the next set of material that I have, but I think in 2009, to the release of a Government of Canada policy called Building the Canadian Advantage, which was about developing this idea that Canadian companies operating internationally have some kind of corporate social responsibilities. A CSR counselor was appointed. This didn't really work out so well. And so between the next period, we have Doing Business the Canadian Way, a new version of the federal government policy, starting to actually say businesses should respect human rights, and that might include Indigenous rights. And then when we move to the last period, we have the creation of the CORE, the Canadian Ombudsperson for Responsible Enterprise, which is an initiative that is not just focused on the mining industry, as earlier versions had been, but also includes textiles. And the newest policy in 2021, titled Responsible Business Conduct Abroad, where finally we see clear endorsement of an expectation for respect for human rights by businesses, an expectation that this includes Indigenous rights, and a few little brief references to environment and climate, but no reference to a right to a clean, healthy, and sustainable environment, despite the fact that in many countries in the world, this has been part of their constitutions and part of their laws for a very long time, including countries in which Canadian businesses have operated. So I'm not going to say a lot about those initiatives, but I did want to note that they're up there and we can sort of talk more about them later. The key point is, though, that all of these are focused on the idea that something needs to happen with regard to Canadian businesses operating internationally. It's abroad. It's never framed as this is for all Canadian businesses. And my claim at the end is that it really needs to be, and this will link in part to the work of the OECD and its guidelines and how we might want to think about those as part of this conversation. So briefly, I did note that this first sort of moment in 97 when I was going to school, despite the fact that Section 35 dates from 1982, we really didn't talk a whole lot about Indigenous rights, and I think that was probably the case at many law schools across the country. 2007, the UN Declaration is endorsed at the General Assembly, but Canada votes against it. By 2010, we're saying, well, maybe. Then there's the Truth and Reconciliation Commission report, calls to action. When we get to 2016, Canada says yes. And then Murdered and Missing Indigenous Women and Girls Inquiry, more calls to action, calls for justice. And now 2021, we have a statute, an implementation act, lots of things happening. Certainly at least no sense that there is a denial that Indigenous rights or the UN Declaration are an issue or real or of importance. I think we are in a very different place than we were in 1997 when it comes to Indigenous rights, and that's very good. For those who think about international law, this slide is just one I use sometimes to kind of reflect on, of course, the problem with recognition of Indigenous rights is that it really calls into question, and particularly when you're located somewhere where there is a historic treaty. So in Nova Scotia, there are the peace and friendship treaties which underlie the relationship, yet Dalhousie is located on ancestral and unceded lands. As an international lawyer, what does this say about Canada and its legitimacy, and Nova Scotia and its legitimacy? And what does it say about international law when we say that we look to treaties as a source of law? Whose treaties? Whose custom? How do we understand all of this? So there's I think there's also much more openness now to sort of critical engagement with international law and international law making. And so when we think about instruments like the UN Declaration on the Rights of Indigenous Peoples, the traditional international law analysis is, well, it's a General Assembly resolution, so it's non-binding, even though it reflects lots of treaty norms and customary norms. But what about the views of Indigenous peoples towards this? Shouldn't their understandings and the understandings of those who worked for 50-some years to lead to this declaration be considered in our sort of legal analysis? Now, how to do that? These are all open questions, but I think it's an important piece of our international law and a part of the business and human rights conversation. Now, interestingly, this also links nicely to business and human rights. If we look at the Truth and Reconciliation calls to action, there's one that's specifically aimed at the corporate sector. And what's funny, or sort of funny, if you go to the Government of Canada website, is they say quite clearly the corporate sector in Canada is responsible for the response to Call to Action 92. Then, of course, the call to action calls on the corporate sector specifically to adopt the UN Declaration and so on as a reconciliation framework. I think this is interesting because if we think about that sort of trajectory and then think about it in light of what else was going on at the time, we can see that at the same time, there has been this move at the United Nations Human Rights Council to develop and adopt guiding principles on business and human rights, which were adopted in 2011. And a key piece of the guiding principles, which I see more on this slide, is the idea that states have a duty to protect human rights, but that we should anticipate that states are often not in compliance with their duty to protect, and therefore businesses have an independent responsibility to respect human rights. We should assume that states are not always doing what they should be doing. Businesses are not off the hook if they say, well, we're just following state law, that's the end of our job. No. The end of your job is to look and see what is the international human rights regime telling you about what you should be doing, and being conscious of that no matter what state you're operating in. And so I think this is sort of going backwards. It's also interesting. I pulled up this image from the Hudson's Bay Company website as it's sort of reflecting on its history, to see it as a key player in sort of the colonization movement in Canada, kind of reflecting on its role in that history, which is what any company should do that's thinking through a business and human rights lens. Now, where it should go with that is a separate question, but I think it's quite an interesting sort of piece and links sort of the story about Indigenous rights with the business and human rights movement. The other piece I wanted to note on this portion of the slides is that the UN Human Rights Council adopted guiding principles on business and human rights in 2011. And instantly, the OECD guidelines for multinational enterprises were revised. Those guidelines date from the 1970s, and they have a bunch of different chapters, and they were initially aimed at businesses operating internationally, but have gradually come to be for all multinational enterprises everywhere, and increasingly for small and medium-sized enterprises as well. So in 2011, they were amended and instantly amended to include a human rights chapter, which is mirrored pretty much identically on the guiding principles, an expectation that businesses adopt a human rights policy, engage in human rights due diligence, and take responsibility for harms that they have caused or to which they have contributed. So I think those are important things that were happening. This picture is actually of the latest version, which now adds the terms responsible business conduct and dates from 2023, and we'll sort of get to that in one moment. But that's the first two sort of steps in terms of evolution. Another one is the adoption by the international community of Sustainable Development Goals in 2015. And so this is an interesting move, and I think part of the story of how to think about business and human rights in the Canadian context. Before the SDGs, there were Millennium Development Goals, and those were focused just on developing countries. The SDGs are for everyone, and the SDGs have a lot of different goals that are interdependent and interconnected and should be understood through a human rights lens, and that includes through a business and human rights lens. There's a tendency to sort of cherry pick different goals and say, I'm working on these three, whereas they're really supposed to be understood as an interconnected and interdependent whole. So there's some work to do in terms of how they are used and whether they're used the way that they could and should be, and there's some potential flaws within them. I've noted SDG 12, which is to ensure sustainable consumption and production patterns. but I've in other materials sort of critiqued the SDGs by saying whereas they're very specific in their targets under sort of SDG 1 and 2 when it comes to no poverty, so they're saying we must alleviate poverty in this way, they don't actually say anything in SDG 12 about we must reduce the overconsumption of the affluent in this way. And so that's a missing piece that should be reflected upon. What the SDGs have done, or what they're a part of, though, is also an evolution in how we think about international law. So in one of the books that I've co-edited, we talk about environmental justice and how the social justice and human rights dimension needs to be linked with environmental issues, and how we need to understand this as a collective whole and not give economy, not see economy as something that's sort of off there to be balanced against environment and society, but rather to understand economy and society as necessarily only working if you've got an environmental floor, a resilient environmental floor, and if economic activity is within the sort of ceiling of planetary boundaries. But I think from an international law perspective, it also tells us that we shouldn't really be learning about economic law over here and not thinking about environment and society at the same time. And also when we're thinking about environment, we need to be thinking about how it links to society and economy. And that's tricky, right? But that's our job. And so moving to the last piece, pretty much, getting there, we have 2015 to 2022. This is a longer period of time, I think, than some of the others, and I'll note that in 2017, I moved institutions, which was also interesting because I'd spent 10 years on faculty at Western Law, which is a very business-focused law school. And then I found my way out east at Dalhousie University and part of the Marine Environmental Law Institute, which is, there is business stuff happening there, but certainly within Mel Law, it's a very environment and marine environment focused space. It's been interesting for me to reflect on the different student bodies in how they respond and understand and engage with things and what their bottom line assumptions are, because they're not the same. And that reinforces, I think, what I was saying on the previous slide about the importance of having these cross-cutting conversations, which of course can be quite difficult. Note that in this move lead-up time, in 2021, we have the Canada's new strategy, which has gone from being called corporate social responsibility and Canadian advantage and all of this, to now being called the responsible business conduct abroad strategy. This is deliberately and intentionally reflective of the terminology used by the OECD. They've called their new 2023 version includes explicitly the words responsible business conduct in the title, but they have referred to what they do for a very long time as RBC, or responsible business conduct. So that's something we'll reflect on in a minute. But what I see being where we are and where we're going is also informed by further evolutions at the Human Rights Council. So not in this period, for the first time, a special rapporteur was appointed on human rights and environment. There has been for a long time a special rapporteur, a special expert working on issues of toxic substances and human rights. Now there is also a special rapporteur dedicated to climate change and human rights, and that's just in the last couple of years. The first special rapporteur on human rights and the environment, John Knox, produced what I think is a really rich and important document in 2018 called the Framework Principles on Human Rights and the Environment. And I've reproduced here the first 3 principles which talk very clearly about how to understand this relationship, that states should ensure a safe, clean, healthy, and sustainable environment in order to respect, protect, and fulfill human rights. And then secondly, that states should respect, protect, and fulfill human rights in order to ensure a safe, clean, healthy, and sustainable environment. So rather than seeing environment over here and human rights over here, these are intimately interconnected. And then the third piece is that states should prohibit discrimination and ensure equal and effective protection against discrimination in relation to the enjoyment of the right. And so there's a lot more to these guiding principles, but I think to these framework principles, but I refer to them often because I think they are very rich in terms of providing a clarity on how to understand the human rights and environment relationship. And this is particularly important because in July 2022, after a 2021 Human Rights Council vote in favor of the right to a clean, healthy, and sustainable environment, we find at the UN General Assembly the adoption of a resolution recognizing this right. Unlike the UN Declaration on the Rights of Indigenous People, Canada voted in favor, with a little qualification that said, we're not exactly sure what this means, but we're sure people will figure this out over time, and we're happy to be part of that conversation. I paraphrase, obviously. But this is interesting. Nobody voted against this one. There were some abstentions for different reasons, but nobody voted against it. Now, what is this right and how do we understand it? And what's in the declaration or the resolution? One thing that's in the resolution is reference to what I just pointed out, the 2018 Framework Principles as being an important guide for procedural environmental rights in particular. But another reference is to the UN Guiding Principles on Business and Human Rights. It's explicitly noted in this resolution, and so I think we can firmly say that states have voted in favor of the idea that business responsibilities to respect human rights include a right to a clean, healthy, and sustainable environment. What does that mean? That's where things get tricky. I had the privilege of doing some work for the UN Environment Program, including developing training materials on a human rights-based approach to the plastic value chain. And I was asked to do this at a time when I knew nothing about the plastic value chain, about the plastics problem, and was shocked and horrified and devoted time with a group of students, which included Akin, to figure out how we were going to respond to this request, which also came out of the coordinating body of the East Asian Seas. And so there's a whole, we had partners in the Philippines and in Indonesia, and this was an extremely interesting and challenging project. So plastics is something to watch out for. The UN is currently attempting to negotiate a treaty to deal with it. But like climate and biodiversity, UN environment treaties are not the end of the story in terms of the work that needs to be done. And a very key piece, I think, is going to be the work that needs to be done by the business community. And I think that includes thinking through a human rights and environment lens. So this image, which I think is a little bit blurred, sorry about that, is one that we used in our training materials. And what I'm trying to sort of show here is the interdependence of what I'll call the substantive components of the right with the procedural components of the right, with this cross-cutting attention to non-discrimination. So substantively, we could think of a right to a clean, healthy, and sustainable environment as including rights to clean air, clean water, safe climate, resilient ecosystems and biodiversity, safe and sustainably produced food, and non-toxic places to live, work, and play. This is the terminology or versions of the terminology coming out of the Human Rights Council and reporting in relation to this. But there's also a procedural component. So it's nice to think that states are going to realize those rights for us all on their own, but that's not going to happen. It's been long understood in the environmental context that procedural environmental rights are very important, and the 2018 Framework Principles nicely elaborate on how to understand that. But this includes access to information about activities that may cause environmental harm and affect us, freedom of expression, rights to science, to education, public participation in decision-making, and access to justice in event of harm. And there's a whole suite of things that sort of go into this, including precaution and impact assessment and so on. But then across the bottom is this idea that those who are most vulnerable to environmental harms are often in vulnerable situations because their human rights have been violated, sometimes due to colonial systems that have created these situations of vulnerability and others. But it's the failure to respect human rights in the first place that can contribute to environmental vulnerabilities. And so those in that situation must be at the center of decision making and must be enabled to exercise their procedural environmental rights to realize the substantive environmental rights. So that's my version of sort of what does this right mean, which we're not quite yet at in terms of this being a dominant, common, well understood idea, but I think this is where we are going. I did want to note, though, that of course this conversation about a right to a clean, healthy, and sustainable environment needs to also be understood in light of Indigenous rights, Indigenous laws, and this is just a slide reflecting on some work coming out of the Mi'kmaq communities in the Nova Scotia context about re-indigenization principles for transforming biodiversity conservation. So I think these are different but parallel kind of movements that need to be understood together. I'm going to wrap up because that's probably where I need to go. So I'm just going to whip very quickly through these last slides. This is just taken from Canada's 2021 RBC Abroad strategy, which again, abroad responsible business conduct doesn't really include a right to a clean, healthy, and sustainable environment, even though many countries in the world do, and so that needs to change, among other things. And so my last reflection on the future, aside from the right to a clean, healthy, and sustainable environment and the need for this to be fully embraced, it would be great to see an overcoming of this problematic inside-outside distinction that, responsible business conduct is for companies operating outside of Canada. What about inside of Canada? How do we understand that? And also a conversation about how to understand responsible business conduct standards, which I'm not going to get into now, but I think there's often a very problematic, these are just voluntary. To be mandatory, they must be within law, but I think there's a conversation about legal relevance of risk-based due diligence that I hope we unpack. And then just to note that links very much to the work of the OECD, which has many chapters, which I think are rich and provide great potential. This is one of the designs we did, drawing on some of these things for our plastics trainings, some other ones. Unfortunately, Canada does not have the best OECD national contact point. I wish it did. And that's where I'm going to stop. Thank you very much.